You spent
it changed
20
over
years
time.
as a prosecutor, 20 years as a prosecutor. You know the answers to these questions. I'm done asking them. I'm just going to go with no.
Would depend upon the actual design of the individual item. There were numerous different items being manufactured.
ATF estimates that not requiring the $200 stamp from the NFA for a short-barreled rifle.
34.
Congress passed a law. They didn't. When did the U.S. House pass a rule classifying a pistol brace as a short-barreled rifle?
Let's discuss the latest developments regarding the pistol brace rule and the ongoing cases against the ATF, which include the nationwide injunction cases. Overturned injunctions on pistol braces. The cases involving ATF pistol braces have reached a critical point, as the ATF is currently requesting that the Fifth Circuit reverse various lower court rulings that effectively prevented the implementation of this rule. The ATF contends that the lower courts either made a mistake in their analysis or issued injunctions that were overly broad, going beyond what the lower courts were authorized to do. In all of these consolidated cases, the ATF is seeking to overturn the limited injunctions granted to organizations, as well as the nationwide injunction that protects individuals' right to purchase and use braces in specific configurations without registration following the rules prescribed SBR procedure. As of now, the nationwide injunction granted in Brito is still standing. There has been a lot of uncertainty and worry regarding the legality of purchasing, possessing, and using some of these items. Fortunately, nationwide injunctions have been put in place as a result of the Brito lawsuit, and there are also more limited injunctions for organizations and their members, such as the SAFE case. Everything that is now safeguarding the use, possession, and configuration of specific braced pistols, the FBC case included, is going to be reviewed by the Fifth Circuit, which will then decide whether or not to eliminate those safeguards.
When did Congress pass a law saying pistol braces qualified? I'm not asking you about short-barreled rifles. I know what short-barreled rifles are qualified as in the National Firearms Act. This pistol brace was sold in 2012. A guy walked into a gun store, bought it legally, walked out of the gun store with the pistol brace. 2012, a guy in Dickinson, North Dakota walked into a firearms store and bought a gun legally, correct?
Supreme Court decisions. The scheduled oral arguments for all of these pistol brace cases are set to occur during the week of August 5th. Nevertheless, the Supreme Court's ruling in the cargo bump stock case are still pending. The Rahimi possession case, which involves the application of Bruin to issues related to domestic violence, restraining orders under federal law, and a person's ability to purchase, use, and possess arms when subject to those federal laws, is still set to be decided this month. Additionally, multiple Chevron deference cases, which are significant and will impact the application of certain ATF rules and other agency rules concerning the Second Amendment and pistol braces, are also pending. This is all significant, and while we have a tentative oral argument schedule set, many things could change depending on what the Supreme Court decides in these cases. Although the ATF has already lost once in the Fifth Circuit in the Mock v. Garland case, they have decided that the lesser of evils is to appeal to the Fifth Circuit and hope to get some limitations on the nationwide injunction that was issued, or on the more limited organizational injunctions that were also issued. Recently, in the Brito v. ATF case, Judge Matthew Kaczmarek issued a preliminary injunction which blocked the pistol brace rule in its entirety, while the case proceeded toward a merits decision. The decision by Judge Kaczmarek was based on a previous ruling by Judge Reed O'Connor in the Mock v. Garland case. Therefore, the orders from the Brito case and the Mock case are temporary measures while these cases move toward a decision on the merits. In the Mock v. Garland case, the Fifth Circuit reviewed it and found that Judge O'Connor should have granted an injunction. They also issued language suggesting that the lawsuit had a good chance of winning on the merits. The case was sent back to Judge O'Connor for a second look. and he finally agreed that a preliminary injunction should have been granted. He granted one, protecting FBC and its members, as well as a couple of companies named as plain defendants, including Tactical Machining. The mock case was the first big victory, and the Brito case built off of it to get the nationwide injunction. The ATF wasn't happy about that, so they appealed to the Fifth Circuit again, seeking to overturn all of those decisions. In their current appeal, the ATF argues that the Federal Circuit should rule that the lower courts were mistaken due to the incorrectness of the Brito case. They claim it was unnecessary for some of these subsequent cases to follow the events in mock.
Your suggestion that somehow, if we've not served in a combat zone, that we don't care about protecting the lives of our constituents.
Yield to a member on the Democratic side that served in a combat area designated zone and deployment of our country. And the answer to that question is a true what would be defined as a weapon actually used in war. We're talking about is a semi-automatic rifle that only is used in a semi-automatic forms.
ATF's arguments and pleading issues. In their ruling, the ATF argues that the district court in the Brito case erred in relying on the mock decision. According to the ATF, the plaintiffs in the mock case did not include a logical outgrowth claim in their complaint or their motion for preliminary relief. Instead, they expressly waived any such claim even after court's decision in mock. Thus, the district court's award of relief on that ground violates the fundamental principle of courts deciding only questions presented by the parties. The ATF claims there were pleading issues and motion issues in some of the language, arguing that mock cannot be used because it was based on a logical outgrowth test. This test pertains more to preliminary injunctions and procedural matters. Essentially, the ATF is saying there were errors in how the other cases were pleaded, making it inappropriate to rely on what the Fifth Circuit said in mock. Moreover, the ATF argues that even if the likelihood of success on the merits was present, none of the parties can show that the pistol brace rule actually causes irreparable harm to the plaintiffs or the public. The ATF contends that having to pay the NFA tax or go through the NFA process for braced pistols does not constitute an injury. They also argue that since they waived the tax stamp fee, there is no injury. The process had to be completed, but the tax did not have to be paid, thus negating any claim of harm. Finally, the ATF argues that the allegation of a Second Amendment violation is not enough to prove irreparable harm. The ATF maintains that these arms, in their configurations, are indeed short-barrel rifles. They assert that because these are classified as short-barrel rifles, they are considered dangerous or unusual weapons. Interestingly, the ATF continues to use the term dangerous or unusual instead of the conjunctive test dangerous and unusual, which is the accurate standard.
That weapon and this weapon are exactly identical. There is no difference. This is a semi-automatic handgun. As quick as I depress the trigger of this Glock 19, a round comes out of the chamber. Glock 19 comes with a 15-round magazine, which under this bill is legal. E320, which some of you probably saw in one of the hearings on the magazine bans, I showed mine. Functions exactly the same. As fast as you depress the trigger is as fast as a round comes out.
Potential impacts. Here are a few things to keep in mind regarding this appeal. First, the ATF is attempting to remove the nationwide injunction that was issued in the Brito case. Second, they are trying to remove the protections that were granted and issued to the two-way organizations and their memberships. Now everything is coming to a head, and oral arguments are tentatively scheduled to take place on August 5th or sometime during the week of August 5th. We think it's merely the week of August 5th, but a lot can still happen, mostly due to the Supreme Court's current activities. One major reason there's a great likelihood of the oral arguments being delayed to a later date is because we have the imminent outcome of the Cargill bump stock case. Once decided by the Supreme Court, this case will have a direct impact on ATF overreach. As a result, by the end of this term, in late June or early July, you can expect to see briefings in all of these pistol brace cases and mock. These cases will probably be delayed for oral arguments, so we don't think the argument date will necessarily stand. Additionally, other cases are currently awaiting decisions from the Supreme Court. You also have the Big 2A case, which is the Rahibi case. This case deals with the application of the Second Amendment and Bruin towards other issues, such as who are the people protected by the Second Amendment. Finally, there are other cases dealing with agency powers in general, primarily Chevron deference. You have the Loper Bright Enterprises cases, and all of those cases will deal with whether or not Chevron deference survives and goes forward as an actual legal canon that can be used. So, there's still a lot going on. The oral arguments in the brace cases have been tentatively scheduled, but we anticipate that because of these Supreme Court cases, a lot is going to change. Just wanted to give you a heads up that we have some arguments set up, but we have a feeling that the current situation in the Supreme Court will lead to some changes.
Not because of rank and file law enforcement doing their job, but because somebody made a leadership decision in order to execute a warrant in the most. You can sell 6 a.m. and standard operating procedure. You can do that everywhere else. I've represented 3 officers and officers-involved shootings. I spent 10 years. I know the facts of this case. I know where the guy worked. I know that he was surveilled. Right? If you have a gun and you're a prohibited person, that's the crime. There doesn't need to be intent. There doesn't need to be any of those things, right? I said earlier that ATF's responsibility is to implement the laws that Congress passes.
34.
Congress pass a law. They didn't. When did the U.S. House pass a rule classifying a pistol brace as a short-barreled rifle?
That's all for this video, folks. See you next time.